Nobody in the courtroom that morning could have predicted what was about to unfold. The Supreme Court chamber was hushed, its grand marble columns and towering ceilings echoing every word, every pause, every gasp. This was not just another case on the docket. This was Millbrook County versus the Federal Environmental Agency, a battle that had already been dubbed a turning point in administrative law. But what the audience was about to witness went far beyond legal arguments. It would become a dramatic confrontation that tested the balance of confidence, intellect, and constitutional principle. As the case began, the Solicitor General delivered the government's opening with ease. His voice carried authority, his gestures polished from years of arguing before the highest court in the land. Reporters in the press section nodded, already sketching out headlines predicting another victory for federal agency power. The gallery seemed convinced that Millbrook County's challenge didn't stand a chance. And then came Pam Bondi. Dressed in a sharp blue suit, calm yet focused, she stood at the podium with her notes neatly arranged. "Mr. Chief Justice, and may it please the court," she began, her voice steady and unwavering. She framed the case not as a minor dispute over regulations, but as a fundamental constitutional principle. Could federal agencies reshape the balance of power between states and the federal government without clear congressional authorization? The tension rose almost instantly. Justice Clarence Thomas broke the silence with a probing question, followed by Justice Alito pressing for textual interpretations. Bondi handled both smoothly, weaving her answers with citations to statute and constitutional principle. The observers were impressed, but they knew the real test was yet to come. That test arrived in the form of Justice Sonia Sotomayor. Known for her sharp intellect and relentless questioning, she leaned forward, her gaze fixed on Bondi. Then, with a tone that sliced through the chamber, she declared, "Ms. Bondi, your argument fundamentally misunderstands decades of established precedent. Perhaps you should revisit basic constitutional principles before presenting such theories to this court." The words hit like a thunderclap. Gasps rippled through the audience. Reporters exchanged wide-eyed glances. Even seasoned court observers shifted in their seats. This was not just judicial questioning. It was a direct rebuke, an attempt to intimidate, and everyone knew it. But Pam Bondi didn't flinch. She didn't falter. Instead, she calmly opened a leather-bound folder, her face composed, her voice unshaken. What she would say next would leave even Justice Sotomayor momentarily stunned and begin a courtroom exchange destined to be remembered for years to come. If you're ready to witness how one advocate turned intimidation into triumph, stay with us. And don't forget to like this video, share it with friends, and subscribe so you never miss the moments that reveal the true drama behind America's highest court.
Long before that heated exchange with Justice Sotomayor, Pam Bondi had already built a reputation for doing the unexpected. But no one imagined she would be standing at the center of one of the most consequential federalism cases in decades. Millbrook County hadn't originally chosen her. In fact, she wasn't supposed to be anywhere near the Supreme Court that day. The case began as a simple local dispute. The Federal Environmental Agency had imposed sweeping requirements on the county, demanding that state-level resources be restructured and budgets redirected to meet federal standards. Local officials argued that the agency had gone far beyond its statutory authority, but few thought their challenge would survive long. The county's legal team prepared to fight, only for disaster to strike. Their lead counsel withdrew suddenly due to health concerns, just weeks before the case was scheduled for oral argument. Millbrook County scrambled. Who could step in, prepare, and argue such a monumental case on such short notice? That's when they turned to Pam Bondi. Bondi was no stranger to the spotlight. She had served as Florida's first female attorney general and spent nearly 2 decades as a tough prosecutor. But by the time Millbrook approached her, she had returned to private life, consulting and writing. The county officials expected her to decline. Instead, she listened carefully, reviewed the case file, and saw what almost everyone else had missed. This isn't just about environmental regulation. This is about constitutional balance. This case could redefine how agencies interact with states. In that moment, she committed. For 6 months, she buried herself in research. She scoured not just legal treatises, but also the writings and opinions of the very justices she would face. Among them, she studied Sotomayor's body of work, her majorities, her concurrences, her dissents. Most advocates stop at the surface. Bondi went deeper. She found subtle threads, recurring concerns about unchecked agency power, even in opinions where Sotomayor otherwise sided with federal authority. Her strategy was clear. If she could turn Sotomayor's own reasoning into the foundation of her argument, she might not just survive, she might win. So when she walked into the grand marble courtroom that morning, observers thought she was simply a replacement, a late stand-in with little chance of swaying the court. But they were wrong. Bondi wasn't just prepared. She was armed with precision, precedent, and the determination to prove that the Constitution still mattered. This was the stage, and soon, the battle that everyone thought would be routine would become legendary. If you're finding this story as gripping as we are, hit that like button, subscribe, and keep watching, because the real fireworks are only just beginning.
The Supreme Court chamber was packed, every seat filled by reporters, scholars, law students, and ordinary citizens eager to witness history. The Solicitor General had already spoken with polished authority, reinforcing the government's narrative of decades of precedent supporting broad agency power. His confidence filled the room. Most believed Millbrook County's case was already lost. But then Bondi stepped forward. Her presence alone shifted the atmosphere. No theatrics, no dramatics, just calm determination. She began her argument with clarity. This case asks whether federal agencies can fundamentally reshape the relationship between states and the federal government without clear congressional authorization. Our Constitution requires the answer to be no. Heads turned. Observers leaned forward. This wasn't the language of administrative law. This was constitutional principle, elevated and sharpened. The justices engaged quickly. Justice Thomas pressed her on federal power over interstate issues. Bondi responded smoothly. Yes, interstate pollution requires federal attention, but not unlimited control. Justice Alito followed with a technical statutory query. Bondi flipped to her notes, citing the specific language, narrowing the meaning with precision. The courtroom murmured with approval. She was holding her ground. And then the air shifted. Justice Sonia Sotomayor leaned forward. This was the moment everyone had anticipated. Her reputation as one of the court's fiercest interrogators was well earned. Lawyers often described her questioning as a stress test. If your argument had cracks, she would find them. Ms. Bondi, Sotomayor began, her voice sharp, you speak of constitutional principles, but you're asking us to overturn 4 decades of settled law. Stability in the law matters. How do you reconcile your position with the court's consistent recognition of agency expertise? It was the kind of question that could shatter an unprepared advocate. Reporters scribbled furiously. Law students whispered, sensing a turning point. But Bondi did not falter. She acknowledged Sotomayor's concern, then drew a line. There's a difference between deference to expertise and permitting agencies to restructure constitutional relationships. One is necessary, the other is unconstitutional. Sotomayor pressed harder. Her questions became sharper, her tone more dismissive. At one point she declared flatly, perhaps you should revisit basic constitutional principles before presenting such theories to this court. The courtroom gasped. The comment stung like a public rebuke. Lesser advocates would have cracked, but Bondi only reached for her folder, calm as ever. She was ready for this, and what came next would shock everyone because Bondi was about to use Sotomayor's own words against her. Stay tuned, and if you want to see how one moment of brilliance can change the course of a case, make sure you subscribe so you don't miss what happens next.
The chamber froze in silence as Pam Bondi opened her leather-bound folder. Those closest to the bench leaned in, sensing something significant was about to happen. With steady hands, she flipped to a tabbed section, looked up at Justice Sotomayor, and said, "With respect, Justice Sotomayor, my argument is not only consistent with precedent, it is directly supported by your own written opinion in Rodriguez v. California." The words landed like a thunderclap. Reporters stopped writing. Justices glanced at each other. Even Sotomayor's expression shifted from stern defiance to sudden surprise. Bondi read aloud, her voice clear and unshaken. When agency action fundamentally alters the balance of state and federal power without clear congressional authorization, courts must examine such claims with particular skepticism. It was Sotomayor's own language, her own principle, now turned back upon her. The justice reached for her notes, flipping quickly through pages. The gallery buzzed, whispering that Bondi had pulled off something extraordinary. And she wasn't finished. Bondi cited Sotomayor's concurrence in Thompson v. Department of Interior, highlighting her concerns about expanding agency authority without congressional approval. Each citation struck like a carefully aimed arrow, piercing the assumption that Sotomayor would remain firmly on the government side. Other justices leaned in. Justice Gorsuch nodded. Justice Kavanaugh whispered something to Barrett. The Solicitor General looked uneasy. Even Justice Breyer, normally supportive of agency power, scribbled notes more furiously than before. What had begun as an intimidation attempt was now turning into something else entirely, a dialogue. Sotomayor's tone shifted. Gone was the dismissive rebuke. In its place was probing engagement. "Ms. Bondi," she asked, "even accepting your characterization, how do you distinguish this case from Western States Regulatory Commission v. EPA?" Bondi didn't hesitate. The critical difference, Justice Sotomayor, is congressional intent. In Western states, Congress specifically authorized coordinated implementation. Here, the statute contains no such authority. She directed them to the appendix, page 428, showing the contrast line by line. The effect was electrifying. The justices weren't dismantling her argument anymore. They were testing its boundaries, exploring its implications. Bondi had done the unthinkable. She had shifted the entire frame of the case. From that moment forward, everyone in the chamber knew they were no longer watching a doomed underdog. They were watching a historic legal battle turn into a historic confrontation. If you're still with us, hit that like button, because what comes next is the jaw-dropping conclusion that nobody saw coming.
3 weeks later, the decision was handed down, and the legal world was stunned. In a 6-3 ruling, the court sided with Millbrook County. Even more shocking, Justice Sonia Sotomayor joined the majority and authored a concurring opinion that echoed Bondi's exact framework. Her words were clear. While courts rightly defer to agency expertise in technical matters, we cannot abdicate our responsibility to ensure that agencies act within the bounds of their statutory authority. When agency action fundamentally alters the federal-state balance, we must require clear congressional authorization. It was a landmark statement. Scholars immediately dubbed it the Millbrook Principle, a new standard that agencies would have to meet before claiming sweeping powers. Law professors updated their syllabi. Legal commentators declared the ruling a turning point in administrative law. But perhaps the most unforgettable moment came in the courtroom itself after the decision was read. Justice Sotomayor walked over to Pam Bondi, extended her hand, and said with a smile, "That was masterful advocacy. You made me think differently about my own precedent." For Bondi, it was more than a victory. It was proof that principle and preparation could overcome even the fiercest challenge. What matters, she later told law students, isn't who makes the argument, but whether it is faithful to the Constitution. The legacy of that day rippled outward. Courts began applying the Millbrook Standard. Agencies reviewed their own regulations. And in classrooms, students studied not just the decision, but the process, the confrontation, the turning point, the triumph of reasoned advocacy. In a polarized world, one truth stood out. Even the sharpest conflicts can lead to respect when the Constitution is the guiding star. And that's why this story matters. It isn't just about one attorney or one justice. It's about what happens when preparation meets principle, and when integrity triumphs over intimidation. If you believe stories like this restore faith in our institutions, don't forget to like this video, share it with others, and subscribe to our channel. Because here, we bring you the moments that prove the system can still work, and the confrontations that reveal true character inside America's highest court.